I'm Matt Guichard, and this is No Holds Barred. In today's episode, we're going to talk about common real estate law issues. I'm pleased to have with me Randall Davis, a partner in the Walnut Creek law firm of Israel and Samuels, real estate attorneys. So welcome, Randall. I'm pleased to have you here, and we're going to talk about real estate law, lots of different things. So first of all, why don't you tell us a little bit about you? You work as a partner with Samuels, Israel and Samuels?
That's correct. We are a law firm in Walnut Creek, California. Been practicing about 40 years. My partner is Eric Samuels. The Israel was Larry Israel. He's deceased now, but we carry his name.
Gotcha. Well, today we do want to talk about lots of the issues that come up in real estate. Now, we could be here for a couple of weeks talking about things. But in general, what I really want to frame it with the idea of it's an area of law in buying and selling property. Most people understand that. But we think of all the disputes that can happen in buying and selling property. We can think of the issues that happen with neighbors. We can think of non-disclosures and all that. So that's just a little bit of what we're going to talk about, and probably more. What I'd like you to do, first of all, is kind of let us know when somebody buys a piece of property, they get a broker or a real estate agent, and the other side typically gets that. And what do they have to do? What does a buyer have to do, for example, in terms of a contract? How's that work?
Well, it's rather interesting. You're not required in California to have a broker to buy or sell property. We would recommend you get one, but they do charge, and they charge a fee that can go up to 6% overall, usually, for the sale of residential property. And I think you're seeing less and less people use brokers. But I think they are invaluable to find properties in this market, and they are invaluable in providing some non-legal information to you about the purchase and sale of the real estate. They do earn their commission. One of the things brokers will do is will have you sign a contract where they represent you. They have various types. They have exclusive and non-exclusive contracts. Depending on whether you're a seller or a purchaser, more likely as a seller, you would want a non-exclusive one so that other brokers could also list your property. But generally, brokers want an exclusive contract, and they want it for a certain period of time. And if they bring a buyer to you, they're going to want to be paid whether the buyer comes back and purchases for some time after the contract expires.
Gotcha. One thing I do want to talk about, and it's a very interesting point, I think, is let's jump all the way to the end. There is a dispute. In that contract, is there a provision to, say, arbitrate a dispute in terms of the purchase? Or how does that work? So somebody gets into an issue and says, well, wait a minute, we're in a dispute. What's that contract say?
Now you have a scary topic. Arbitration provisions are in all the general form contracts provided by the California Association of Realtors for brokers. Same with the commercial groups. Arbitration is not required. You don't have to sign that provision. That means that you're basically waiving your right to a jury and to appeals. It may not be in your best interest. And in some cases in California, even if you sign it, it may not meet the requirements to be enforceable because it may be substantively and procedurally unconscionable under the circumstances. So I always feel that you can always arbitrate your matter. You don't have to agree to do it when you sign the contract.
So is there a certain area in the contract where you can specifically opt out of an arbitration?
Actually, there's a place to opt in, usually. It's a large bylaw required to be in black type. in the real estate contract. It's and a separate place for initial signature and a checkbox to say that it's included. Many brokers will check the box in advance. The thing is, don't sign it.
Mm-hmm. Well, it sounds like kind of brokers are kind of like lawyers when it comes to contract. You want your broker or real estate agent to explain every provision of that contract to you before you initial and execute it. Isn't that correct?
To the extent they deal with the real estate and the contents of the real estate, that is correct. The legal ramifications of some of the things that people do in purchasing property, what is included, what is not included, who gets to go, who gets to stay, those type of things really need to be discussed with attorneys.
I see. So that would be your recommendation if somebody has a broker or a real estate agent. And let's just jump to that. What's the difference between a broker and a real estate agent in the real estate field?
Well, there are brokers, agents, and realtors. Brokers actually own the brokerage. They actually have the ability to broker loans in the state of California and to run the office. The real estate agent is an agent of the broker. Even though by California law they will be considered an employee, they act as an independent contractor, usually paid by commission on what they eat, they kill. The realtor is a designation that is provided by a private organization that shows your qualifications to be a broker or real estate person of high integrity and intelligence as well as experience.
That's interesting because we recently did a no-holds-barred show on how to select a lawyer. And would you then recommend that you go through a process in seeking out either a broker and a real estate agent, doing a little research, or just go with your brother-in-law's ex-broker?
My recommendation is always go with a local broker with a larger firm. One, the reason is they know the local market where your property is situated. So they know values. They know what you'll be able to get for it. I also think with a larger firm, you're not running into, I'm not going to give you attention because I have a bigger deal going on. And that happens a lot of times with small real estate brokerages.
Interesting, interesting. Well, let's talk about, we'll get past the idea of the contract, which I think is always important. In the law, we tell people you should have a contract. That's important. You should discuss it with somebody. And I like that thought of yours is if you're making a big purchase, a lifetime purchase, you probably ought to talk with a lawyer as well as talking with your broker or agent.
Well, if for no reason other than to know how you should take title to the property, that's important. In many cases, it's not going to be in your best interest to take other than your own home where you're going to live in title in your name.
Well, what would be an example of in taking title some other way than in your own name?
Well, you could take it in trust, and that'll help you, should you die, get it to your successors without paying probate in California. You could also put it into a limited liability or corporation so that your other assets that you may have are not at risk if something should happen with that particular property.
This sounds a little more complicated than one would think. So there's an awful lot to think about when you're purchasing either a commercial piece of property or a home.
Well, even if you're going to be a landlord and rent the ADU in your backyard, I suggest you consider setting up the ADU as an LLC or as a corporation to avoid the person, if something should happen, taking your home.
Gotcha. Thank you, Randall. It was really interesting talking about, general concepts of purchasing real estate, really by the common person. I think we like to think of it that way. For our audience, stay tuned for our next episode of No Holds Barred. We're going to talk some more about common problems in real estate law, and we're going to have Randall Davis discussing those matters with us. If you like this episode, hit the like button, hit the subscribe button. We really appreciate it.